So, welcome. This is our first episode of our trademark podcast with intellectual strategies. In this podcast, we're going to explore the world of trademarks and with a focus on their significance for businesses, particularly with startups and growing businesses. We do have to put a disclaimer because we are attorneys, so we want to make sure that you know this information is provided for informational purposes only and not to be considered as legal advice. So make sure you consult with a qualified trademark or business attorney to get specific information on your legal needs. So to jump right in, today we're going to walk through the initial trademark process, and we're going to give you some insight and information onto how a business can obtain a registered trademark and also the benefits of the purpose and benefits of having a registered trademark. With us today, we have Jeff Holman. He is a patent and business attorney, and he is also fractional in-house counsel for several businesses. He is the founder and visionary of Intellectual Strategies. And myself, Danielle Byford. I am a trademark and business attorney working with Intellectual Strategies. Jeff, any other information you want to add?
Yeah, I just want to say I'm glad to have this conversation with you. We've been talking about it for a while, and I just working with you over I don't even know how long it's been. It's been over a year, maybe 2 years, in fact, that we've been working together, and I've just really enjoyed working with you and getting your insights on the trademarks that we've done for our clients. I mean, as you know, we kind of cover a lot of services across the board because we act as general counsel and even a fractional legal team for a lot of startup clients. And every client we have has some trademark issues. They're all trying to build a brand on top of the products or services that they're selling. So it's been great working with you. And, it's been interesting as we've gone through kind of the full cycle or life cycle of some of these trademark issues, from filing to examination to even some oppositions on both sides, to some asset purchases where people are buying or selling trademarks, to some disputes. And it's just been a lot of fun. I think I love sharing with clients that this is where a lot of value is in small businesses, statistically speaking, and you'll probably touch on this a little bit, I would think, but statistically speaking, their businesses are worth more because they have trademarks. They will sell for more money if they're purchased by somebody else or bought out. And that's a pretty cool place to be when you're working your life away sometimes to build a business. You want to know that you're getting the value out of it, or that you're hopefully getting the value out of it in the end. So anyway,
Right.
It's just an important part of what we do.
It is. It's kind of, I like to think of businesses as your baby, and then you're helping them grow into a child and an adulthood, and having a brand name that you can then trademark is kind of helping them graduate through the steps of their business.
Awesome. With that said, how about if I walk through and maybe ask some questions, you can give some answers, and we'll have some discussion on a few things. Does that sound like a good approach?
Perfect. Yes.
Fantastic. So maybe just to start it off, some of these might be softballs, so forgive me, but can you briefly explain what a trademark is and why it's important for businesses?
Yeah. So a trademark is, in essence, a sign, or not a sign, a symbol, like your logo, what you see when you walk into the business. It can also be a word or your phrase, your tagline. And this is what the particular part of a trademark is. It distinguishes your business, its goods and services, from that of another business. And so your business with your trademark, it's your unique identifier for your source of goods and services. It helps build brand recognition. It also gives, when you have a registered trademark, you have that R symbol. So you can use it to kind of gain reputation and your reputation in the marketplace. So people will grow to trust you. So I like people to think about it when you're walking through the grocery store and you're looking at the actual products. You, even though you might not realize it, you see that R symbol and you gain to trust that brand more.
That's very good. I think a couple of keywords I always hear when I hear people talking about trademarks is they'll often think of their trademarks and their brand as the same thing. They're not, but they're close, right?
Hmm.
Your brand is identified by your trademarks. That's what people are going to see, and that's how they'll refer to your products and services. The other thing I hear a lot of times is goodwill. People say, "Oh, there's a lot of goodwill with that company." You know, that's maybe they're really talking about what the reputation is of the company, how the market feels about that company, whether that's a positive reputation or not, perhaps. And so those are all very tied together: the brand, the trademarks, the goodwill of the company. It's
Yeah.
fantastic.
I like that a little more also because when you talk about the brand being different from perhaps the business name. So that's also where we have a lot of questions where the business name might not necessarily be the brand name. So your business could be one overall, but then you have a bunch of different brands under it, which will all serve as brand identifiers for that particular good or service that you provide.
Yep. Fantastic. Now you mentioned the circle R a little bit. Circle R, as you and I know, designates that somebody has gone through the registration process and they've completed it successfully. There's actually an examination, right? And if you don't complete the examination, you don't get the registration. But if you complete it, you get the registration. And there are a lot of benefits to that. What are some of the benefits to having a federal registration for your trademark?
Yeah, so there, as in essence, there's three. So one, it grants you basically legal ownership and exclusive rights to use your trademark in connection with those goods and services. So you get national protection, so across the United States for that particular brand name. And then you have an umbrella of goods and services. So through that, you can send cease and desist letters. You can start enforcing your brand in the marketplace. So this makes you able to prevent others from coming and infringing not only on your brand name, but similar uses of that brand name. You also can take legal action against infringers. So there's some areas underneath the statute where you might not be able to go after somebody that's infringing on your trademark if you only have common law trademark rights. So once you have that federal registration, you might be a Utah entity and somebody in New York might be using your trademark. If you don't have that registered trademark at the federal level, you might not have the standing to go after a New York company. So there's that additional value there and being able to have that. And then we also have the third benefit I see is in our e-commerce industry. More and more platforms, whether it's Facebook, Amazon, Etsy, require a trademark registration before they will give your shop the ability to sell your goods or services there.
Yeah, I was really hoping you were going to bring that one up. I had a call with a potential client just this morning. She's selling a cosmetic product and has a brand. I like the brand, but was talking about getting it trademarked. And I mentioned Amazon's brand registry, which of course is Amazon's program that you're talking about to be able to get additional services and protections on the Amazon platform because you're in the registration process. I talked to her about that and she didn't know anything about it. So she's just a newer e-commerce seller and was glad to hear that, you can take a pending application or a granted registration and use it to help shut down other people who are copying your product or your brand. So it's fantastic. I'm glad you mentioned that. Tell us a little bit about the registration process. What's involved, how long does it take, things like that.
So there's different methods to approach the trademark registration process. There's some that will just go through, apply for the trademark on the USPTO website, cross their fingers and hope for the best. Our recommended strategy is usually to conduct a comprehensive search. So to go through, identify any potential obstacles to registration and give a recommendation on what would be an issue that they might face and hopefully be able to overcome those issues down the road. Once we go through that search, we identify the either brand name, slogan, logo that we want to apply for. We go through the online trademark system, which I think we'll go over more in a follow-up podcast because that could be whole episode in itself.
Yeah.
And so basically, once we apply for the trademark, we have a waiting period, which can be several months to 6, 9, 10 months, depending upon how backed up the USPTO, the Patent and Trademark Office, is. Once it gets filed and we go through the waiting period, it'll get reviewed by a trademark examining attorney that will identify either issues with the trademark, or if everything is copacetic, no issues, it'll move forward on through the process, which will then be an opposition period. If you are not in use, you'll have to file a notice of allowance to prove use of your trademark. And then if everything goes well, at the end of it, you'll get a registered trademark.
That sounds like a lot, and you put it very simply. So there is a lot there to unpack. If everything goes smoothly, then it's a really easy process. And when you run into bumps, then that's where I know some of the DIY trademark filers kind of scramble and realize that what they did, they filed something that wasn't quite right, and they couldn't fix it, and they had to basically restart the process. And so that 6 to 9 months that they waited is just gone, and that filing fee that they paid is gone, and you've got to restart. So anytime
And
I
a lot
have
of
somebody,
those,
oh,
yeah, a
go
lot
ahead.
of those issues are easy to avoid by doing that initial, just the application correctly to start with.
For sure. I'm glad you put it that way. And I think we might go over this later, but you keep referring to the U.S. Patent and Trademark Office. That, of course, is the administrative office in the United States that takes care of all of the patent and the trademark issues. And then other countries will have their own trademark processes, and each country will examine and they will grant registrations and enforce those registrations by country, right?
Correct.
Yeah. We can probably talk about a little bit more about the international process as we go. Let's see. So you went through some of the steps of registration. Could you talk just a little bit more about the what are the key factors that a trademark examining attorney will look at for determining whether or not they can register your trademark application?
So the first thing that they're going to look at is to make sure the application actually meets the statutory requirements. So they're going to go through, make sure the applicant's ownership is correct. So if you're listed as a corporation, but you put in partnership, you're going to have an issue there. Domicile address, where you do business. So they're going to look at just the initial application. After that, they're going to go into the more comprehensive review, which will be determining, is there a likelihood of confusion with another mark that's already been filed and registered? And this is a key point here. So they're also going to not just look at registered trademarks, but in the United States, it's the first to file. And so somebody that might have already filed before you, even if it's not registered, could stop your trademark from moving forward. And so they're going to look to see if there's a likelihood of confusion by doing their own search. Then they're going to look to see if the mark is descriptive in any way. And so later on, we'll go through what is actually a strong trademark, but they're going to see, is this descriptive of a quality ingredient process for that goods and services? And then they're going to look at some other items like, is it a surname? Is this geographic? There's a whole manual of all of the items that they'll go through. And then if there are any issues, they're going to give you an office action. Or if there aren't any issues, it'll get moved on towards an opposition period.
Okay, fantastic. I like to summarize those things because there are a lot of them that the examiners look at, but the two that come up for every single application, a lot of the others don't necessarily come up as issues, even though they're considered, but the two that always come up are what you mentioned: likelihood of confusion, or some people call it distinctiveness, right? Is it distinctive from other applications, or is it likely to cause confusion with other trademarks out there? And then the second one is descriptiveness. Does it describe the product or the service or the features of the product or service that you're trying to brand? So that's fantastic. What are some of the Well, before we move on, anything else that you want to share about the registration process? Things that applicants or startup business owners should know about the actual application process itself.
It is a long process. And so, just a reminder to be patient. There's no way for us to push an application forward unless you have very specific requirements, which usually is a federal litigation lawsuit. So, it is just to be patient, and the examining attorneys are not adversaries to you. So even though it seems like they're reviewing this, they really want to do their best and try to help you. And so I just want to make sure that as you go through the process, knowing that the examining attorneys are people too, they might make mistakes. They're doing their job, but they're not adversarial. It's not an adversarial proceeding.
Yeah, that's a great point. I've worked in both patents and trademarks, and I can say that working with trademark attorneys is a lot easier than working with patent examiners. They are much more collaborative and helpful to get your trademark application through the process if they can be. So, what are a couple pitfalls that you've seen business owners run into, or maybe misconceptions that they might have about trademarks?
Yeah, so I would say the first is they do just a simple Google search on the exact name that they want to use, and they go, oh, I didn't find anything here. I'm going to start using the product. And then later on, they receive a cease and desist letter. Or they go through the process, they file for the trademark, and it alerts a competitor. And so those are some of the pitfalls where they didn't do the initial due diligence to make sure that they can use this brand name on their goods and services. So they might end up having to rebrand later, which can be more costly, especially if it's on goods, because you already purchased the packaging or the label, which can get pretty costly if you can't actually sell out of it. And then I also see another pitfall where they identify, oh, the domain is available, so that means I can use the brand name. They don't do any more. They just go into Google Domains or GoDaddy and they see the domain is available and they think the domain name is a brand name. And so they start using it, which can run into other issues later on as well. And then the last misconception I usually see is just the confusion. I think we touched on this at the beginning, is the difference between your brand name and your business name. And so that is, I think, a big misconception, is that your business name can be different than what your brand is. And you can, as a business owner, have several trademarks underneath your business name. So for example, Johnson & Johnson, they have a whole line of products. Frito-Lay, whole line of brand name products. And so as a business owner, you don't have just one brand, you can have several.
Okay, that's fantastic. Yeah, trademarks seem like they should be a lot more straightforward and less complicated, but there's a lot that goes into it, obviously. So, with that said, what are some of the steps? Let's say a business owner goes through the process, they get a trademark for their brand or for a product. And as you mentioned, you can get one for your brand overall, you can get one for a specific product, you can get a tagline for a service you offer. Let's say they get their trademark registered. What would be the next steps that they should take to try to protect that mark in their business?
So the first that I usually recommend is start using that registration symbol. So that way you signify, it's not a requirement that you use the registration symbol to enforce trademark infringement, but
And
it gives
sorry,
you
the registration symbol is the circle R that you're
the
talking
circle
about.
R.
Yeah.
Yes. But it gives you the ability to give notice to all the others that this is a registered trademark and you are intending to enforce it and protect it. I also recommend setting up, whether it's a monthly Google search or a regular watch service that you use through a provided service to monitor others that might try and come after your trademark. And this is big, especially in the international area, where somebody in another country might see this as a popular trademark. And then also to take steps, if you do see infringement, don't just sit aside, to actually take steps, whether it's sending a cease and desist letter, reaching out to that infringer in a cordial matter, in a more demanding matter. So actually take steps to enforce your trademark through cease and desist. And then as you grow your business, and I know that's what we like to focus on here at our firm, is getting businesses growth and revenue sources, is a licensing agreement. So if somebody else is out there trademarks different from franchising, you can license that trademark, that brand name, and start generating licensing revenue through there.
That's great. I'm just thinking back through some of the things we've worked on. Do any of the clients that we've worked on kind of stand out in terms of some of the steps they've taken and the results they've gotten for their trademark portfolio?
Oh, definitely. Especially with once you start enforcing it. So once you have that registration through brand registry, you can have other, even if it's not the same, but similar brands taken down. So Instagram handles, Amazon brand registry. So having those infringing products removed, and then just generating through licensing. So we've definitely seen through licensing the brand name, their businesses have definitely grown. I think, 8 months, we saw huge growth in one client. So,
Oh yeah, you're being very very general here. Good attorney skills. I'll mention one that I like to refer back to, and that is we have a client who does e-commerce, and they were selling mainly on their own Shopify account through their own website for a long time, and had not made the jump over to Amazon. When they were looking at going to Amazon, they basically realized that they had done so well off of Amazon that many people were copying their product, copying their branding, mimicking their branding on Amazon. And since they weren't there, since our client wasn't on Amazon, these infringers were really doing really well with their own infringing businesses on Amazon. So when we made the move to Amazon, we had gotten the mark into the brand registry program, as we mentioned before, which allowed them basically within the first week of getting into that program and opening their Amazon store, they were able to shut down something like 27 out of 30 infringers that they had identified up to that point. And it was just a very fast cleanup of most of the infringing sellers. So a great result for them. Took some time for some reasons to get a few of the others taken care of. But I mean, that was they were worried a lot about the fact that they had so many people selling, but to be able to go in and use that trademark status to just essentially ask Amazon to take everybody down quickly and to have it done was almost surprising to them.
mhm.
So let's see. Let's move on. Let's see. We talked about taking steps to protect your trademark. Let's skip over international and foreign stuff because I think that might get into a larger conversation. But having a U.S. trademark is kind of a stepping stone into protection in other countries, oftentimes. So we can talk about how that works and where to file and when to file and what to file in those other countries.
Mhm.
What are some of the potential consequences you've seen for businesses that have decided to skip the trademark process?
So you are just so taking back that client and all of those infringers that were on Amazon. Without that trademark, you're limited in your legal avenues that you can actually enforce your brand. So your geographic area is limited, and also what steps you can take. So especially e-commerce, so many platforms don't allow you to report infringement unless you have a registered trademark. So your legal avenues are limited. sending a cease and desist letter, I like to say, does it pass the laughable test? So if I receive a cease and desist letter saying my client is infringing on their brand name, the first thing I'm going to go do is go and look it up. Are they actually registered? Are they actually doing enough to want to enforce it beyond just sending cease and desist letters? If I see that they are actively registered, we're going to take it more seriously than it's not registered. What are they actually doing? Or do they want to enforce this? And then you have more arguments on who was first to use it. Do we actually have the proof there? So if you don't have a registered trademark, you're definitely narrowing what you can do to stop others from using.
Yeah. And that's assuming that somebody doesn't come in and shut you down altogether, right? We've seen a lot of clients who come in and they realize that that somebody has reached out to them saying that they are infringing on that other person's trademark, and they come to us to figure out what their options are. And sometimes, had they done things properly, they might have been able to continue to use that mark in some scope. And sometimes they can, and sometimes it's easier or more practical to just rebrand at that point. So getting limited to a narrower scope or geographic region sometimes is the best result, and getting shut down completely is also a common result. So,
and then also what we see, and I know this doesn't, but when we see businesses selling, when they can't identify. So when you have a buy-sell agreement, you'll specifically list the trademark and the registration, and you have that whole portfolio. But when you don't have that registration, it's hard to manage in a buy-sell agreement and the value you don't get from it. And so that's also where we would see it down the road once your business is ready to graduate college and you're ready to retire.
Yeah, certainly a buyer who's looking out for their own financials, which we would expect them to do, is going to say, well, there's some risk here because you don't have the trademark registration. I don't know if I can protect it. I don't know if someone's going to come after me at some point, and they'll use those talking points to then drive the price down, which is great for them, but not so good for the person selling the business. So let's say we've got a client now who really wants to get a trademark, and they go through the process, they file, but in the end, they're not able to get the trademark. Sometimes you just can't do it. Like, what are their options, or what are the other alternative strategies to think about for somebody who is unable to get a trademark for some reason?
So I would want to look and see, why was it rejected? So were they just not able to prove use? So perhaps they didn't meet the requirements to prove use, but there was no issues with a likelihood of confusion. Then there's no concern with them continuing to use that brand going forward, and we can reapply down the road once we have that proper proof of use. In the United States, we can file as an intent to use. And so you don't have to be in use once you file. And so there are time periods where we can't request enough extensions and it just goes expired because they're not in use. So no concerns with them using that brand moving forward. They got there far enough. They just weren't able to get their feet off the ground. The biggest concern was if it wasn't able to get registered because of a likelihood of confusion. Then we're looking at, if you continue using this, you might be putting yourself at risk to receive a cease and desist letter, possibly rebrand, or maybe it opens up the avenue to reach out to this other business owner and come up with an agreement for both parties to move forward. So there's different avenues to approach there. And then the last is you can just use your brand. If you weren't able to receive the registration and you're just limited to your geographic area, and as you grow, it just depends on what that initial trademark was refused for.
Okay, fantastic. So as I'm just thinking about how I would summarize that in my mind for a client, I would probably say you've pointed out really well that sometimes when a client's unable to get a trademark, you can actually fix that and go back and get the trademark sometimes. So sometimes it just depends on what the reasons were for not getting the trademark in the first place. And then if you are in fact unable to get the trademark in the end for whatever reason, um, then you can look at, I think you said rebranding. You can look at working with another party who has the trademark, and maybe something else. I wanted to explore though that one, working with somebody else. So we've done a lot of agreements lately where parties have decided to work together, and
Mhm.
they've done a coexistence agreement or something like that. Talk a little bit about how that process works.
Yeah, so it's more of just a cordial process that we usually see with business owners because they see not necessarily as a competitor. So there might be something enough different. And even with competitors, we've seen them work together to try to come to a resolution. But the coexistence agreement is really an agreement between both businesses to help foster. If there is a consumer that is confused by the brand names, how they'll work that out, as well as what markets they will, depending on how you work it. So there could be, will only be within the East region, you can be within the West region, or, we're good, just don't go on Amazon and you can sell on any other platform. So the coexistence agreements are just like any other contractual relationship between the parties where they just come to an agreement on how both businesses can continue to grow. And so that's where we like these types of coexistence because it really is business to business. The cost of us entering into this coexistence will be significantly less than if we try to go through litigation and neither party comes out with what they wanted.
Yeah. So what I'm hearing is you basically come to an agreement with the other side, and you divide things up, whether that's which types of products or services each person's going to sell, and it could be the same types of products and services, or it could be different, right? Depending on how the parties agree. It could be different geographic locations, different distribution channels. So you really can define that however you want.
Mhm.
Let me ask this question though. Does that mean that this is like a negative thing for the businesses who have to start splitting things up? Or coexistence agreements bad?
I think it depends on how you approach it. So, in my view, I think coexistence help businesses, especially at the start level, identify a business plan. Sometimes they come in and I want to be everywhere. And then when we look at a coexistence, what are you actually selling? Where do you see your revenue stream coming from going forward? If you are a t-shirt business and you're coexistence might be with a shoe company, but you still want to, if you're never actually going to be selling shoes, your benefit really is okay, now I can see where my business can grow. You also engage a connection. So, another small business owner or medium sized business owner that you can connect with and you continue to grow. So, I like to kind of approach things in a business mindset. I think you do as well as, this is a connection. We can grow here. What's the point of us being mean to each other? And the main downfall I might see with a coexistence agreement is if you are so tunnel visioned, you can't see yourself in 3, 5 years growing beyond the coexistence agreement. So because it's contractual, if you get to the point 3 years from now where you might be able to buy the other party out of that. And so with a coexistence agreement, you're able to maneuver it um, towards the future. But a downfall might be as a business owner if you can't see yourself being able to get out of that tunnel vision.
Yeah. And I will admit now that that was a bit of a baited question, because I think what we've talked about in the past is there are a lot of positives to coexistence agreements. And one that I don't know if you mentioned it was just simply when you have two parties come together and essentially validate each
Mm,
other's trademarks, you're forming uh, some evidence that could be used in court even to suggest that the trademarks actually are more strong or more valid because another party um, has recognized that and come to an agreement with you, right?
yeah.
Yeah, so you get two parties using the same mark in maybe different fields or related fields, and it's almost like cheating in a way, although maybe that's the wrong word to say. It's almost like cheating because you guys come together and you say, hey, let's agree that our trademarks are stronger by coming to an agreement with each other, than if we fought with each other about how strong our trademark should be independently.
Hmm.
So maybe it's a little counterintuitive there, and I like being able to explain that to a client and help them realize, hey, there are actually some really strong positives to working together with another party.
Yeah.
Okay, let's see. We've got a list of questions here, and I've jumped around a bit, so you have to forgive me. But you've done well keeping up with my jumping. Talk about just for a minute about what happens. You get a trademark, and it's good for a certain time, but what does a client have to do to keep that trademark going over time?
Yeah, so in the US, you have to file what's called maintenance documents. So the first time period is between your 6 to 7 years. After that, it moves to 10 years. That time period might change. It's rules, so that period could change. But you, in essence, just have to show to the USPTO that you're still using your trademark. This is a way for the government to make sure that the brands that are staying protected are actually in use in commerce. So that way you're not having dead brand names on the register. So it'll open the way for new brands that are actually utilizing the brand name to go through, but it also makes sure that you are using your brand as your registration symbol. So to get that registration symbol, it has to be on those particular goods and services. So it makes sure you as a business owner are actually using your trademark the way that you applied for. The maintenance documents, it's, proving use. So whether it's a picture of the product, screenshot of the website, and then you have to pay, of course, the government filing fees. But you don't have to go through a full re-examination process. There's no likelihood of confusion or merely descriptive. The only other, which I think is too much for this episode, but what we'll do a follow-up on, if you're on the supplemental register, whole nother area
Oh
that
yeah,
we'll go into later.
it's a different topic.
Completely.
Yeah, no, that's great. So then maybe just on the same point though, of renewals, what does a business need to be aware of if they're going to, in terms of trademarks, if they're going to, let's call it, refresh their branding and make changes to their logo, or maybe even rename themselves or rename a product? What kind of things do they need to be aware of for those future renewals?
So there can't be a material change to the trademark. And so material change, we are still, it's such a gray area. But generally, if there's a letter that's removed that doesn't change the commercial impression or something along those lines, we might be able to argue that it's not a material change, removing the word of or something along there. And so if the rebranding is significantly different with a word trademark, so whether that's your brand name or your slogan, we might have issues with the renewal. With the logo, a material change, if you have a completely different logo, we probably have to file a new trademark. If it's you have two circles and now the two circles are this way or somewhere, we might be able to argue that's not a material change. So that part, it just depends on what actually was changed, and that'll determine if the maintenance documents will be accepted or if we have to file a new trademark.
Okay. So if I were to put that in, let's just call it business terms here, if a business wants to refresh their branding in a way that their clients would have to relearn who that is from their new trademarks, that's probably a material change. But
Yes.
if it were such a small change that the client um, readily recognizes it as the same branding, or maybe it's such a small change that the client doesn't even recognize that there was a change, then those would probably be immaterial changes that might be able to get approved, or I should say might be able to continue under the existing trademark.
Correct.
Okay. No, that's great. And we've had some clients who have made some of those changes, they've changed the radius on the graphical element, so it's a little bit, broader radius or narrow radius, and probably immaterial. But the other thing that we did for them, and we would do for other clients, is we would want to look and see how material it is and see if it justifies us adding a second layer to that portfolio, right? Where we
Hmm.
get a new trademark on the new branding while perhaps maintaining the old trademark on the old branding so that we can eventually swap those out, or having some insight into where they're headed, why they're doing the branding changes, can help us get the right strategy behind that.
Correct.
I'm going to go with two more questions here, unless you have more that you want me to ask. But
No,
the
perfect.
the one I've been waiting to ask here is about famous trademark disputes. Do you have any examples of famous trademark disputes that you want to share?
Interesting. So the most common ones that I think about are with, let's see. So usually with Monster. So Monster Energy will go after any other trademark that uses the word monster. And I think it was 2 years ago, another company actually took it up through the federal court, so not just at the USPTO level, and determined that Monster can't have a conglomerate of other all of these other industries. So that was one. So kind of
In other
opening up
words,
the way.
sorry,
Go
in
ahead.
other words, you can't own the word in every single market.
Correct. Yep. And then, oh my goodness,
Well, while you're
this
thinking of it,
one.
I'm gonna expand on that just a little bit,
Yeah.
because we have clients who come to us and they're like, "I want to own this word. I don't want anybody else to be able to use the word monster or whatever it might be." And we're like, "Well, that's not really how it works. There are these classifications, and you have to apply for a class of goods or products or a class of services, and you get protection mostly within that class and not outside of that class." So there's a whole structure to how the trademark office does that. So you can't own the word, even if you're a famous brand like Monster.
Hmm. And then the other most recent one that comes to mind, it was the international trademark where In-N-Out Burger, who is an international company, but they weren't in one country. I think it was Germany. And to maintain their trademark there, they actually had to set up shop. And so they just did a quick drive through, lasted a week. And it's ongoing. I don't know how it was resolved yet, but another company that was using a similar name filed against them saying that wasn't proper use. So it'll be interesting to see how that plays out.
That will be interesting. We do run into clients. We've had clients transfer cases into us, and we're like, okay, you got to renew this, or you've got to file your statement of use to show you're actually using it. And they're like, well, my last attorney said, if I just do this, and I'm like, we don't want to be like on the borderline cases. We don't want to test
Mm,
that theory whether or not that actually is use in interstate commerce to FedEx your own product from yourself to your second home in a different state. Like that, like this in and out thing sounds to me like it's they're trying to make something fit that probably wasn't intended. So be interesting to see if it works.
yeah,
And
it
I'm
will be.
and I'm glad we're not the attorneys having to fight, having to argue that is valid use. So that'll be interesting. Fantastic. Well, and there is one more point I was going to make as you're talking famous trademarks. Famous trademarks. Tell us about famous trademarks and how they're different from, let's say, normal trademarks.
Yeah, so if a trademark becomes to the point where it's famous, so for example, Apple or Pepsi, so those brand names where we automatically know what that company is, they kind of have more of that umbrella of protection because of the level of fame that they have. There's certain requirements, elements that you have to prove to get there. but it also works on the USPTO level when they review a trademark and they see something come through that might say Pepsi, even if it's in a category that would be completely unrelated. There might be a way for the super famous trademark to try and prevent them from moving forward on the registration. And an examining attorney might cite it as this conflicts with a famous trademark. Monster is a little different because there's so many monster trademarks out there. It's not one of those made up fanciful names like Pepsi or Frito-Lay. Kleenex. Kleenex is a brand name. We all use it as a generic term, and they've fought so hard to make sure it doesn't become generic. And so that's the other concern that we have with trademarks that become so famous. If you brand it so well that it then becomes generic. Pickleball, it's actually a trademark name, but it's on the verge of, is it becoming generic because so many people aren't classifying it as, oh, pickleball's a brand name. They think of it as just the game.
Yeah, I have to say I've never heard anybody ever refer to pickleball as the pickleball paddle sport or something like that.
It is, it's a paddle sport, but everyone calls it pickleball. So that's where when you get that level of famous, how you actually start branding yourself can have a either positive effect on your trademark, or you can end up making yourself generic.
That's fantastic. I hadn't even thought of that side of it, but it makes a lot of sense. Last one was for now, unless you have others, we can go into more stuff, but I really want to know, like, what would be the top 3 or 4 pieces of advice you would give to an owner who is either starting the trademark process for the first time, or maybe just beginning to really think seriously about how they develop their trademark strategy?
So my first advice would be to talk with an actual trademark business attorney. Um, and so there's some trademark attorneys that just do simply trademark filings, but when you talk with an attorney that knows the process beyond just applying for it, they can give you that branding strategy to make sure you grow your brand while being able to protect your trademark. And they can also help with identifying, is this trademark actually protectable, or are you coming to us with a descriptive name that you're not going to be able to enforce? The next piece of advice is to make sure when you start using the trademark to also talk with either a trademark attorney or a business attorney to make sure you're using it in a brand fashion. So many times we see, oh, this is my brand name, but they don't have it on their packaging to identify it as a brand. Or it's on their website, they're a service-based business and they're using it in a non-brand identifier trademark matter. And so working with an attorney that's not just going to file the trademark and move on, but will actually help you identify strategies on how to utilize it. Or if you are just a business owner and you don't want to consult with an attorney, just do due diligence. So to go through and see how your competitor that you know as well at branding, how they're doing it on their website. Don't copy it. That's a whole other issue. But oh, okay, I see that they bolded this and they put it at the top of their page. Or I see on their product packaging, it's in this format, it's not hidden somewhere else. So just making sure that you're doing your due diligence at the beginning of the process so you avoid those issues later that we addressed earlier.
I like that, and I would probably try to put all those into one category, which is, I mean, you can own a trademark, you can get a trademark, but I think what you're really talking about is how do you build the value of the trademark as opposed to just having a trademark, and that's by using it properly, that's by developing it within the business strategy that the company has, um, and even within the broader competitive context of who you're in the same industry with. Um, I think all of that is really about building the value of the trademark as opposed to just getting a trademark. So that's great advice. Well, any last words that you want to share with anybody here uh, on this. What are we calling it? A podcast? What are we calling this? A
A
podcast? A
podcast?
blog post? A video? Any last words you want to share with anybody about the trademark process?
No, I do have one question for you though, and that is how at Intellectual Strategies can we help these startups and business owners navigate the initial trademark process?
That's a fantastic question. Um, Let me start by saying, and I'll refer back to what I mentioned at the beginning, and that is we really try to take what I call an integrated approach with our clients. So we want to work very collaboratively with clients. Um, to the point where we might be in their office on a regular basis, just present and available to have some insight into what the team is working on, because you and I both know is if we sit in our home offices or wherever, um, we only hear about the problems that people call us about. But if we're close to the team, working with the team, kind of in the mix, we hear about a lot more stuff happening, a lot more opportunities, and maybe a lot more problems that we can prevent by being integrated with our clients. As we do that, I think we see a lot of opportunities to help build brand value where clients might not otherwise think, oh, I should think about trademarking that. Or on the other end of it, oh, maybe I should do a search to make sure that I'm not creating infringement risks if I do these things I'm thinking about. Um, so being involved in the client's business gives us a lot more insight. The other thing I would share is that, and you talked about searching and filing and did a great job explaining a lot of the pieces of that. Sometimes I talk to clients who are early on in the process, and they think of getting a trademark as just one action that goes all together. And I think it's okay to split them out and say sometimes it's okay to think of the searching and the clearance around using a mark separately from actually getting the trademark registered, because you can get, you're given under state law or common law, you're given some level of protection, even though it's pretty minimal, just by using the mark. And a lot of clients are, they're testing out their market, or they're just launching something and seeing if the brand is the right brand. And so they don't necessarily want to put all the effort into, you know, a commitment of the next 18 months to get a trademark registered if that specific service maybe has a shorter lifespan. But so they're kind of in those testing phases a lot of times. And I'm like, well, listen, let's separate let's do the search, and let's get some risk assessment done around, if you launch with this and it works, are you going to have a relatively clear path to protect it, even if you decide, whether you decide to do that protection now or down the road, as your budget grows, or whatever the factors might be. So I think being able to separate those out in time, um, and early on get the real risk assessment is extremely powerful, even if you aren't filing immediately as kind of the same action in that same time frame. So that's what I would say in answer to your question.
I like it.
So
That's all I
awesome.
had.
Well, it sounds like we've maybe come to the end of this discussion on trademarks here. So Danielle, I just want to say thanks for all the insight you've provided here. I know we've got a couple other videos or podcasts that we are planning to do, and there's certainly almost an endless list of topics that we can dive into for trademarks and protecting our brand. So anyway, thanks so much, and let's chat more.
All right. Thank you.